because over the next 25 years, there's an expected $10 trillion in wealth transferring to the next generation. This is important because currently over 60% of wills are being contested. So it's important that you have your wishes correctly documented. So your wealth is transferred to who you want when you want it to be transferred. To this end, I'd like to welcome our guest speaker, Grant Abbott, who's a specialist in estate planning and superannuation. He's actually a pioneer in this space. He's also the founder and current chairman of SEPEPA, the Succession Estate Planning and Estate Planning Association of Australia. I got that slightly confused. Sorry about that, Grant.
That's okay.
And he's also the author of the best-selling book, Family Wealth Protection, which hopefully people can see. No, you probably can't see it on the screen, but anyway, it's a great book, great read. So it's now my pleasure to hand the session over to Grant, and welcome, Grant.
Yeah, thanks for that, Wayne. And hello, everyone. So that's the book. Unfortunately, it's rare as hen's teeth now. You can still go on Amazon and get it on Kindle, but the first edition's sold out. So we're waiting. I've already, and this was only in November, so I've already done a second edition. It's just getting proofread now. So we've inserted quite a bit on child maintenance trusts. In fact, I did a session this morning with Divya on child maintenance trusts. So that was to a family law firm, whereby those people who are having to provide child support as a parent can in fact do it through business assets, which would result in getting a tax-deductible child support payment. So it's quite a wide open space. What I'm going to do is I'm going to share my screen. This is being recorded. Wayne will send out the videos a little bit later on. That's the video that I sent through for you just earlier. So that's the Child Maintenance Trust. So let's go to this one. So we'll go for about 45 minutes. If you've got any questions on the way through, just throw them into the chat or the Q&A. Wayne was quite rightly talking about there's a couple of things. There's a transfer of wealth of $10 trillion in Australia over the next 25 years. That's nothing. Over in the US, it's $78 trillion. And you can follow, like, there's stories about it everywhere. US is a lot easier than us, so we've dealt with a lot of US practitioners. Over there, whatever you put in the will effectively stays in the will, or it gets allocated as is required, unless the will is contested from a legitimate point of view or legal point of view. And we'll talk about that a little bit later on. Importantly, over there, they use a thing called a living trust. So they're enabled prior to their passing to, or on their passing, to transfer all of their assets into a trust, which by all imagination I've actually ripped off and utilised that, which enables, when we go through, and I'll show you how it works and the strategies and ideas and some of the areas there from taking the best of the best from the UK and following the British royal family, taking this concept of the living trust from the US. And importantly, because they're both trusts, they're both based on what we call law of equity, which applies across India, Singapore, most Commonwealth jurisdictions, the US, and effectively is a great vehicle for protection. Because when we're protecting, as Wayne said, there will be a lot of money that goes from one generation to another, but the majority of wills have no protection, no succession planning in them at all. And the problem about that is that you may end up whereby monies are passed down to a child, whether it's a daughter or a son, and then we find that within a short space of time, or 2 or 3 years, that inheritance, which the parents have worked so hard for over a period of time ends up being dissipated either through poor business decisions, poor investment decisions, or more often than not, family law claims. With over 60% of all relationships now, 60% seems to be a magic word these days, 60% of all family de facto and also marital relationships breaking up. And I'm a testament to that one, I can tell you that. We have a position now that assets are going to form matrimonial properties. So when we're looking at family wealth protection, we're not only looking at the first level, we're also looking at the second level. The other side, in between levels, the passing the generation, and I'll talk about that a bit further as we get into the slides, is those family provision claims. Only around about 3%. There's, as I said, if you're an eligible claimant, so for example, in New South Wales, it's very, very open. South Australia to a lesser extent, but in New South Wales, if you are a child, a stepchild, an ex-spouse of any equation, so it might have been 30 years ago, 25 years ago, you're all able to make a claim on the estate if you believe you should have been provided for. So you may well have been left out, or money may have been left to you. But if that money isn't enough to satisfy your financial needs, you can find a no-win, no-fee lawyer to basically litigate your case. They'll come in and if you fit into one of those categories, and there's even been carers that are able to make claims. There have been friends who have financially been relying on other friends or brothers or sisters who are also able to make a claim. And the famous case that we always talk about, which has really shocked many people, because the majority of Australians, couples have family homes in joint names, so that if one person passes away, it goes to the other person in CALP. And CALP in New South Wales, as I said, is extremely egregious. And I know my fellow compatriot attorneys over in the US shake their heads when they hear about the Australian system, that in CALP and CALP, we had a stepson making a claim on his, making a claim on his father's estate 2 years after his father passed away. He'd had a ski accident and was in pretty severe trouble. The only problem was that all of his father's assets had passed over to his wife, which was his stepmother. All the assets passed over, and there was the bank account, a range of shares that paid dividends, and also the family home that they'd been living in for 37 years. The court basically held that given his dire health circumstances, that he should have been provided for adequately from the will. So they come about it from a different way, not percentages or whatever. They look at what his financial needs are. And he was allocated $700,000 from the will. His stepmother had to sell the property, and they said it was appropriate for her to downsize and look after, the estate should be looking after him given his circumstances. And that sort of left a really bad taste in many people's mouths, because at the end of the day, the other 4 children, which were her children, missed out because they didn't make a claim on the estate of their stepfather or their father. So that now there was only a certain amount that was left for mum when she passed. And likewise, then her stepson could make another claim on the estate. So it's a crazy situation. It's not so much, and that case ended up in court. Only 3% end up in court. Most are settled prior to that. 90% are all made claims by adult children. You may have one child that, you want to give everything proportionately, but one child is down at luck and the others are quite successful. Well, the down at luck can say, well, hold on, I should be paid more from the estate. And again, they have to show that they need more in order to sustain an appropriate lifestyle. So going back to that, it's not so much, for those of you who've ever been involved in litigation, it's not so much the actual end result, but it is going to be the potential litigation time, which can take anywhere from minimum 2.5 to 5 to 7 years. And more importantly, the expense inside the Family Wealth Protection book. And again, if you want to get a Kindle, you can go to amazon.com and .com.au and get it from just Family Wealth Protection by Grant Abbott. But a new edition will be out within the next probably 2 months. From that in there, I also talk about the case of Miller and Anderson, which was a pretty, not a in terms of the scheme of things, wasn't really a big standout case. Andre Miller died with a $600,000 property over in Perth. He'd been having a dalliance with a live-in, which he didn't really live in. She was sort of cohabiting with him on and off for about 14 years. He'd done a will, and his 2 children got everything, and his de facto or live-in, live-out partner, Angela Miller, made a claim on the estate, and she ended up with 40% of the $600,000. So the children, lost a little bit. But the problem about the case is it went for 5 years. By the time it got to, so Angela Miller's part of the estate was $240,000. But by the time it got to court, her legal fees were, in fact, $299,000, and the lawyer concerned adjusted down to $199,000. So she ended up with $41,000 out of the whole equation. And in fact, the whole of the estate ended up paying the executor and the other 2 children, his 2 children. By the time you bundled up all the fees, it was $520,000 in legal fees. So a lot of people say, I don't want to rule from the grave, but if you don't rule from the grave, you're going to end up in a bit of strife. And it may be in that switch over from one generation to another, as Wayne rightly pointed out, or if we don't bundle up and provide some protection for our children, it'll get lost in terms of family wealth. So this is what it's about. So our goal throughout today, I'm just going to give you a lot of strategies. As I said, the video is going to be available. I've already given you a short video there as well. Get a copy of the book. It'll, as Wayne said, it'll lighten, certainly enliven your brain around this area. The other side is make a booking with Wayne to come and have a consultation with me. Wayne will take all your relevant details. I need to know all about your family, where the risks are, whether it's at a business stage, whether it's a family stage. We get the risks, and then Wayne does a great briefing paper for me, and then we sit down and have a chat. That first session is free, which is pretty good, because normally from our legal firm, LY Legal, we normally charge $1,000 for that initial session, but due to our relationship with Wayne, there's no cost on that. So please book in as soon as possible for no holds barred. So it's better to find out where you stand and what can be done, rather than putting our head in the sand. But I'm assuming that's the case anyway, because you wouldn't be on this presentation anyway if you weren't concerned about it. So what we want to do is build a castle. So in the castle, we might have, for example, here's our little self-managed superannuation fund. We might have here the bulk of it's our family protection trust. We might have out here a child who's disabled, so we've got a special disability trust. At the back here, we might have one of our children who's taken part of the trust, and they've set up a little sub-trust within our compound. And they might be looking after a farm or something. So, but out here you can see we've got this other little structure here, which is not covered by the moat. So that is exposed. And many people see people with investment properties or their family homes sitting outside the moat. And unfortunately, it is exposed to litigation, exposed to the ATO. Wayne would tell you that he's getting, a number of his clients are getting director's penalty notices and very egregious claims from the taxation office, who went very light on in terms of COVID, but is now coming back extremely aggressively to shut a lot of businesses down and close a lot of people out. So there's nothing worse, and I find it terrifying that particularly business owners finding out they're going to have to home and tell their spouse that they've lost the house. And I've seen a couple of occasions of that, which we help and we go in and fix up, which is great. So what we want to do is build a big moat around the house so that if the lawyers, doesn't matter whether it's a tax office, family provision, no win, no fee, if they get in, it's going to be, how's your father? So they're going to have to get past the piranhas, the alligators, and everything else. So if they want to make it over there, they're going to have to spend a lot of money to do that. And I tell you what, that's one thing no win, no fee lawyers don't want to do. Okay, so I won't go through a lot of that. I might go through a couple of things. What happens if there's a legal suit on your assets for death or incapacity? That's a family provision claim. Incapacity is a really interesting one. We're starting to see a lot of litigation by children once their parents lose their mental capacity later on in life. They seek to take over guardianship. At Elway Legal, we recently dealt with a case where two children had an enduring power of attorney. There was 4 children in the family. The 2 of the children took $1.8 million out. Believe it or not, it was authorised, but it was unconsciously, it was an unconscious gift to themselves, an unconscionable gift to themselves. And we're trying to claw back that $1.8 million. So you've got to be extremely careful around those enduring powers of attorney. We have had other instances where one child has got an enduring power of attorney, another child is trying to take guardianship over the parents. So that's taking full financial control, not obviously for healthcare necessarily. But they're taking financial guardianship over there. And then you've got the public trustee trying to do the same thing. If it ends up in the public trustee, it's all over. So you might as well put all the money down the drain. So again, we want to make sure that we're fully protected. Assets in your own name are obviously extreme blunder. From a tax perspective, it's important. Investment properties in your own name, you've been able to negative gear. I've done another video on why negative gearing is in a self-managed super fund is 10 times better than negative gearing outside. Again, if you want to find out a bit more about that, just let Wayne know. We can talk about that at any discussion. Likewise, family properties in our own name are also, they get the tax exemption, the capital gains tax exemption when we sell our property. But again, I'll just hearken to the fact is that, if we've got a jointly owned property, one of the couples dies, and so then the exclusive legal title goes to the surviving spouse, but then the surviving spouse gets into a relationship for more than 2 years, or someone lives in the property for more than 2 years, they've got a right to make a claim on that estate. Now, they might get a huge amount. They might only get 10 or 20% or 30%. But at the end of the day, they are entitled to make a claim. I always tell about the story about my daughter, Sophia, who had a really good friend down in Victoria. Her grandmother gave her a property while she was alive, a very magnanimous grandmother, and then her boyfriend, she'd been living with for 4 years, and this girl was only 26, up and left, had to sell the property, and took $900,000 out of it. So again, we've got to look for all the nooks and crannies, and that's what our discovery session with Wayne does. I'm going to show you a little bit later a solution called the Protector, which is really important for that one. If you're running a company, one of the ones, unfortunately, there's over 3 million. I think there's now 3,100,000 companies in Australia. Most of those are single director companies, which creates a problem because if you've got a single director, then you need to have a line of succession. So if the single director passes away or becomes incapacitated, who's going to take control of that company? And particularly if the company is a trustee of a self-managed superannuation fund, or the trustee of a family trust, or it's an operating company, it's running a business, or it's a bucket company where there's a lot of cash. If you haven't got a director in there, the whole thing grinds to a halt. And I've seen it grind to a halt for 3 or 4 years, bringing all the business and investment decisions in a family trust or a SMSF grinding to a halt and no one being able to do anything. And can you imagine that when you've got volatility in the stock market, knowing you can see that you might be a beneficiary or a member of a fund, and you can see it going like this, your balance is going up and down or going down the toilet, and knowing that you can't do anything because the person who set it up for you really hasn't set it up properly. We dealt with a case study yesterday, in fact, a client circumstances where dad had passed away. Mum's got it's got the family home, which is okay, but she's got dementia. She hasn't got a will, so automatically we're up for intestacy. They've got 3 boys there. She's got no money whatsoever. They've got a family trust that's got a property. And inside the family trust, dad had a whole lot of shares, but didn't keep a record of any of it. So they keep on getting these things coming in, and they don't know where anything is. They, beg their dad later on in life to tell them where everything was, and now they're destitute, and one of the sons is not in a good way financially or physically. And that has created a major issue there for them financially to look after their mum. So again, we've got to make sure we look for all of those weaknesses. For a company, absolutely crucial to get a successor director in place. In fact, you don't have one, you have 2 or 3, because we should all know Murphy's Law, that if you only have one, there's a good chance that both will end up. The same thing is that a lot of them say, okay, well, mum and dad or a couple of spouses, the directors, what happens if they both die together? That can create major circumstances. Again, we'll go through and we'll talk about this leading member. I'm not going to cover contribution strategies, but if you've got a tax bill this year, and particularly if you've got a self-managed super fund, I can show you how to really make a huge dent in your tax bill this year. But I won't go through it. These are 30 June strategies. Again, make that appointment. I've written 5 books on self-managed super funds, I think Wayne said, and I'm doing my 6th book at the moment. But there's a big section in the Family Wealth Protection book on SMSFs from family wealth protection point of view, but the strategy side will be coming out a little bit later on that one. Okay, small business owners. This is anyway. So from a legal firm, we're finding now, it's already starting to happen, that artificial intelligence is making a significant impact on the legal profession. When we have a look at it, lawyers now becoming a lot more productive. So people who are first year out of law school or even interns are no longer being placed, mainly because AI is now taking their spot. The senior partners are happy about that because it means that there's more money for them in the long run. And each of the major legal firms have developed their own AI system and are doing so. And it's now going down to a lower level. We're soon going to find, and already conveyances are automated, and you can get a conveyance now for like $350, which is absolutely crazy. But AI will have an impact on that. Wills, you would never go to a suburban lawyer for a will because, again, they don't know how to protect it from a family wealth protection point of view. But it means there's a huge squeeze now that lawyers are looking to litigate more and more. And with $10 trillion sitting in the bank accounts and, family property and all of that of the baby boom generation and the generation before that switching over to Gen Z in the next 20 years, as Wayne said, a lot of that's going to be litigated. So the lawyers are going to be happy on that one. And based on that, there'll be easily $500 billion on legal fees just on that alone, maybe even more. We dealt with one case, and this is particularly, again, egregious. So I keep on using that term. We came at the back end. If we'd come in at the front end and been able to advise a client, it wouldn't have been an issue. But they had one child who had a family trust that ran a business. Certainly not what I would have chosen as the operating vehicle. I don't mind family protection trusts or leading member trusts, as we've seen, that have got operational vehicles underneath. But in this instance, Dad had said that when he turns 65, he would hand over the reins to his son. He hit age 70, hadn't done so because he didn't think much of his son. The son took an action against Dad, and it ended up taking 5 years. It cost Dad $7 million in legal fees. So let me take it again. $7 million in legal fees. And they used a concept called promissory estoppel, which is again an equitable remedy that Dad had made the promise to the son had stayed in the business for all that time, and therefore he had a right and entitlement to that business. We're finding that more and more cropping up when we're looking at farms. So again, we're finding that no win, no fee. I did a session on that the other day. You can just go to Morris Blackburn shop. I can give you 20 or 30 names, no win, no fee in your area. So wherever you live, just go down, go no win, no fee in Caulfield, and you're going to find 20. And they'll tell you they get a 99% success rate, which is the case. Okay, so let's go through. I'm not going to go through the protector. Let's start off with the key vehicle. So this is the one that's sitting in your chat. I've got a couple of chats. Let me see. Okay, so you'll see up there I gave at 12, just before it started, I gave a video on Family Wealth Protection Trusts. So make sure you have a good look at that. So Family Protection Trust, the benefit of trust is that, as I said, it's the law of equity. It's been around since the 12th century. The background on it's pretty strong, and it sort of gives you an idea of how and why it started. Is that in those days we had crusaders going off to fight for the king, and this was over in England. While they were overseas, they didn't know that, and the king had generally awarded them land for sacrificing their life for the monarchy. So it would award them land, but because they didn't know they were coming back, they might put it in their brother's name or friend's name. Now, what happened is the title was in their friend's or their brother's name. So when they came back successfully from a crusade, so they actually lived, they tried to claim the estate title, but common law, which is just man-made law, effectively at that stage said, well, hold on, no, legal title is sitting with, for example, your brother. You have got no right or entitlement. Hence, the first introduction of the law of equity, which means fairness, came into existence. And fairness basically said that, hold on, the brother was holding that property in trust for when the brother came back. And so that's where trust came about. Importantly from that, as we go down the track, there's a whole history of trusts. I find it fascinating. Many of you wouldn't, but I'd love to know the history. And Saunders and Vortier, which is an 1800s decision there, one of the issues, and this is pretty important, that the trustee, there was a beneficiary of the trust. So, for example, the soldier was the beneficiary of the trust, which was the property. In Saunders and Vortier, there was a beneficiary of the trust, and it was a discretionary trust, which meant the trustee could distribute income and capital to a range of beneficiaries, quite a wide range of beneficiaries. And in this instance, someone sued one of the beneficiaries and sought to claim access to the assets in the trust. In Saunders and Vortier, which is still law in Australia in equity law. So the equity law isn't usurped at this stage by family law. It's not usurped by trustee law. So in that instance, it was held that no beneficiaries have no entitlement to have an entitlement to any of the assets. So the assets are held by the trustee for the benefit of the beneficiary. The beneficiaries only have the ability potentially to receive a discretionary distribution from the trustee. I'm going to go into that a little bit later on. So what we've built is, again, taken from both US and also the British royal family. We start off, and as Wayne said, it's the Succession Asset Protection and Estate Planning Advisors Association. We start off with succession first, so you can see there on the left. So this is a family protection trust. So on the left, we've got the family protection appointor. So if there's a couple of spouses, this is equivalent to being the kings and the queens of that trust. So you might have your two spouses at that stage. If something happens to like dad passes away, then we've got mum there as the queen of the trust, which is fine. But then she might lose her capacity. The same thing that we dealt with in that case yesterday. She loses her capacity, then one of the children or two of the children might come in as the next in line, that family protection appointor. Remember, we had a look at that company where you got sole directors. You need to have a line of succession. That's all important. And it's not only just for one, because the way we establish these family protection trusts, they go into perpetuity. Most states, and particularly in Victoria, there's a limit of trusts going if they're established in Victoria. Sorry, if they choose their jurisdiction for the trustee to operate as Victoria, then effectively there's an 80-year rule. But we use abide by South Australia. We choose the jurisdiction for the trustee, which we can do from a trust point of view, and then becomes perpetual, which is important. So for our Buckingham Palace, we want to have that really good line of succession. We then have mum and dad in there as a king and the queen. And this is a really important maneuver when we have our family protection trust, is that this is something that we put in place now. It's like the living trust we have over in the US. Just an aside, the reason over the US the living trust is really important. You can jump on YouTube and you'll see a whole, there's heaps of people talking about it. Is that over there when someone passes away, probate and actual administration of the estate goes through the relevant probate courts over there, which might take 18 months to 2 or 3 years. Here, where we've got stuff sitting in a trust, it's automatic, and more importantly, it's protection for the next generation. So with the family protection trust here, so that we might have, as we said, the king passes away, and then the spouse takes over. But then when the spouse and also both of them pass away, it then gets split. So here I've got 3 children. So I've got C1, C2, C3. It could be split all equally. Or for example, if there was a farm in that family protection trust, it might go to C1. So child 1 might end up with the farm, which could be 80% of the assets of the family protection trust. Because it's sitting inside that trust, C2 and C3 can't make a claim on the estate. Whereas if that farm was sitting outside in mum and dad's name when the last died, C2 and C3 could easily make a family provision claim on that. So this is a good way of protecting and passing assets down through generations. Also, we might have C3 might have some mental health issues, ADHD or autism, and we might want to keep more aside for them. So therefore we are able to maybe put 40 or 50% aside for them. If they are able to get a special disability allowance from the government, they meet the relevant criteria. They can't work more than 10 hours a week due to their severe disability. We can take the money out of there and we can put it into a special disability trust. The special disability trust enables them to get social security, and then the normal assets test is relaxed. So you can have a family home in there, or a family home for the disabled child, plus up to $800,000 in assets, and that won't even impact the disability allowance. Plus, it also enables parents, or in this trust, to transfer assets into the special disability trust, and has to be for the disabled child only. But any transfer of assets over there, there's no capital gains tax. So there's a huge amount of relief and also no stamp duty. So again, this just shows you we've got a lot of flexibility. C2 might be an alcoholic or a big spender or whatever. With C2, if they're an alcoholic, we can say, well, there's no capital distributions to you, except in the instance if you're going to get rehab, or there's no income distributions unless you've been sober for 60 days or drug-free or 60 days. So again, we've got that. Importantly from us, unlike if any of you got trusts, or most trusts in Australia, we limit the beneficiaries to bloodline beneficiaries only. So it's only your bloodline children, no spouses, no one who is not in your bloodline. So that, for example, is generally your children. But for example, if C1 has got children, then their share goes down to their bloodline children or your grandchildren. C2, because these are all sub-trusts, C1 is the manager of their sub-trusts. C2 is the manager of theirs. C3 is the manager of theirs. C3 can't complain to C1 about what they're doing. You can either run all the investments. So a lot of our clients, so we'll hold on, what we're doing is all the investments are made up here, and then income is then distributed down to each of these children. Capital gains are distributed down. Or you can have instances where C1 might have the family farm or want to invest in property, but C3 wants to have a balanced portfolio. You can do all of that. But importantly from that is that when mum and dad die, it instantly converts to this. There's no probate. So those family provision claims that we're talking about don't apply to the family protection trust. So that's crucial. That's why we love these living trusts. Plus, the way we do it, we set it up, these trusts, sub-trusts, so that there's no capital gains or stamp duty on the transfer of assets here to C1, C2, and C3. So again, that's fairly important. In some instances, we might have, which is really important, so if mum's just left there, we've got 3 kids there, or we've got 3 young children, mum and dad have passed away, we might have in place a guardian. So SEPEPA has a recognised board of guardians who you can call upon to act as the guardian for the 3 children. So, for example, if we've got mum and dad pass away and they've got 3 children under the age of 18, we might have a brother, and this is important when we have a chat about, brothers and sisters, and so we might have a brother or a mother who would step in here to really act as the administrator of the estate for the benefit of the children, but they're excluded as beneficiaries. Although they're bloodline beneficiaries, we want to exclude them because we don't want them as trustee to pass money down themselves and their children, and that's why we have a guardian overseeing as well. So again, it's a good, clean structure. If we have a look up here, it's got a huge moat around it. Let me go up. It's got a huge moat around it, and just makes it very difficult for people to challenge. So with that one, if you've got any questions, let me know, but I've sent a video through to you. This video will be available to you later on. So this is what we really want. Now, unfortunately, well, not fortunately, look, I don't care the way it is. A lot of us have got businesses, which is fantastic. And for businesses, if they're set up, and my daughter's got a business where she provides AI training to small businesses just to get them up to speed because it's moving so quickly. But she's been operating as a sole trader. And I said, you can't do that. There's too much potential litigation there. So what I've done is I've set her up in a trust, a leading member discretionary trust, and her business is running through an operations company. The shares of that are actually owned by this trust. So again, if we've got a business that's already running in a trust, what we want to do is we want to convert that trust. So we've got an ability. In fact, we just did one recently. It was a 1980 trustee. There was no mobile phones in those days. They were like landline phones. So we can upgrade the rules. So there's no change in the trustee name. There's no change in the bank accounts or anything. All we're doing is we're putting in a stronger structure. So what it is, if I go up to this picture here, let me go up to my picture up here. So if I go up to the picture here, in that family trust, we've got this stuff happening. So the business is in the family trust and it's exposed. So what we're doing is we're pulling it in and we're putting a moat around it to make it protected, and we call a leading member. So much the same as a family protection, we've got a leading member appointor, which is going to be mum and dad, or if it's business, it can quite often just be the business owner or the family person. We could have a son working or daughter working the business, so they're the next one in, so on and so forth. And again, we have our splits, but here in C1, if it's the business being run in there, and when dad passes away, it might go down to the child that's running the business. Again, it passes down, and you don't have that promissory estoppel. You don't have that problem of being caught up in a family provision claim as well. So what we do is we put that big veneer there as well. Bucket company, if we've got that, the shares are owned by this leading member trust. What we in fact do is we distribute everything from the bucket company in through the leading member trust, and we put it into a family protection trust. So you'll see a bucket company will pop its head up out of there. Now, there's a couple other structures we really put in line as well, but I haven't got time to have a look at that. So that's the first thing. So if you've got an existing trust, and you might have 1, 2, or 3, then the first thing I'm going to do is convert them to leading member discretionary trusts. Now, one of them might be what we call fairly clean, that hasn't got much in it. Then I might actually convert that to a family protection trust. This is our Buckingham Palace. All these other ones are like your second tier palaces, if you put it in the context of the British royal family. A couple other things. When we go up here, testamentary trusts. So the leading member discretionary trust is a trust you've already got, you're running business or operations through, or you've got a number of investment properties. So we're going to upgrade that to a leading member discretionary trust. Family protection trust is really where we want most of our major wealth to be, and we'll talk about that. Now, a testamentary trust is a trust that is created on the death through your will. So the first thing we're going to do is line of succession, asset protection. Asset protection is to look at your current trusts, and we're going to make them leading member. That's how we're going to protect your assets. And family protection, we're also going to, that's our asset protection. The third one is estate planning. So in estate planning in your will, what we're essentially going to do is we're going to make it simple but smart. So again, we don't want any assets or any money going directly to our children or to our spouse. So what we do is that when you pass away, or either one of you passes away, your assets go directly into a family testamentary trust. And again, guess what? Same thing. We've got a line of, it's like a family protection appointor, a line of appointors there, family testamentary trust. So if whoever's left over takes control and then gets split amongst the children. Ideally, that's great. But what we want to do, so what we want to do is for that, with our will, we might have a scenario with our will that we've got the testamentary trust there. But if it's all going to turn to cash, if we've got children under the age of 18, we may end up keeping the testamentary trust. But if we've got a family protection trust, then we might cash in all the assets and transfer them into a family protection trust, because we've already got this running. It's already in existence. So the testamentary trust is not needed. It's only ever needed if we've got children under the age of 18, because there's a huge tax benefit there, or we want to keep an asset. Generally, we want to keep a property. So if we want to keep the family house, we've got a couple of years to make a decision there, but there's no duty, there's no capital gains tax on the transfer over to the testamentary trust. Whereas if we transfer those specific assets to the family protection trust, the FPT, there would be stamp duty and potential capital gains tax, unless it was our principal place of residence. So the testamentary trust is absolutely valuable because we want trusts everywhere down the track. But what we've got to do is we've got to decide at that point in time. So in our will, we say we want everything to go here, but if there's adverse CGT, capital gains tax, or duty consequences, then it ends up here. The other one is our superannuation, same thing with our superannuation. So the family protection trust and the super, with the exception of New South Wales, but you guys are in Victoria, our super sits outside our family provisions. So, for example, on death, we might have family provision, promissory estoppel, but anything that's sitting in our super retail or industry fund, with our SMSF, we generally cash out and then we'll put that money into a family protection trust. You don't really want to be left with a huge amount of money in the last person standing in the SMSF, because if it goes out to your children, there's a 17% tax on it. We don't want to transfer the money from the SMSF over into the estate because it may get caught up in a family provision claim. So we want to deal with it directly down in the SMSF. So that's through your adult children, financial dependents, or your spouses. So if it's a spouse, you can just take it over and put it into that family protection trust. So we like waterfall it in here. We waterfall it in there. And of course, a lot of the times we're going to want guardians in all of these, but that's a whole stretch of things as well. Now, there's a lot I could tell, and as I said, I can go through a lot more, but that sort of gives you an idea. We want to use trusts. You'll see in the Family Wealth Protection book, there's around about 11 different styles of trusts that we can use, but they're the three major ones. It's important probably, there you go, it's 11:46, so I've made my time fairly appropriate. The main thing is with that is we really need to see where you are now. Look at your wills, look at your enduring powers of attorney. That's absolutely crucial, and they want that long line of succession. And we need to have a circuit breaker in there because you don't want your children or one child to hop off. It's too easy if they've got access to the bank account. And banks are getting severely restrictive on all of that. The more we can put in a trust, one other thing that I'll just talk to you about that I meant to, I forgot to, is as I said, we've got a whole lot. I'm presuming there. Can everyone see that screen? Yeah. So there's a whole lot of SMSF strategies I'll go through. If you've got super, you must. Yeah, look, I'll show you really what to do with that. One other one is where we have our wealth outside. If you're in business or you're worried about family provision claim, or more importantly, that your surviving spouse, and getting caught up in a family law action, what we can do is we can use.
Sorry to interrupt, Grant. Can you share your screen, please?
Okay, sorry about that. Thank you very much for that one. I did the wrong one, which is what I tend to do. So thank you for that. There we go. So if I come here and we have a look, and I'll just go up to this slide. So this is called the protector. So we might have a property, investment property, watches, or a flash car like Wayne has, or company shares. What we can do there is if we have them in their own name, as I said, they're exposed. If they're in the estate, essentially they're exposed, and we could end up in, they get bundled up and takes 2 or 3 years. Alternatively, we might have these joint assets. They go to our spouse or remaining spouse, who then, gets involved with another person and essentially lives with them for a couple of years, and those assets will end up going to their bloodline rather than solely to your children. So what we can do is we can look at the net worth of those and these ones, which is going to be your value of the home. So this one might be worth $2 million, but it's got $1 million borrowing on it. So it's $1 million there. We might have a Porsche that's worth $350, but it's got $100,000 owing on it. So it's worth $250. So the total net worth is $1.6 million. So what we do is we gift that to our family protection trust. So we get it in operation now. Wayne will set up the ABN, Australian business number, and tax file number, and then you get a bank account for it. So we gift what we call a promissory note over here. So it's equivalent to cash because you don't have the cash. If you've got the spare cash, then we give the cash over, and then we lend that cash back. But essentially what we do is we lend the promissory note back. On a formal loan agreement, what that enables us to do is then take security over these assets. So we can take security over the property. So, for example, NAB might have $1 million owing on it. But then there's $1 million equity. So it means NAB is owed $1 million and they have first priority. So if they have to sell the house, then first priority $1 million goes to NAB, and the next $1 million would then go to the Family Protection Trust. For these other assets, company shares, your watch, and also your car, we do what we call a PPSR, which is a Personal Property Securities Registry, to make sure that it is properly registered. So that's, again, so we've got our legal title in our own name, but essentially what happens there is our wealth is protected in our family protection trusts. So again, as I said, there's a lot there for you to digest. There's 210 pages or 212 pages of the book. Have a good look at Kindle. But the main thing is probably come and have a meeting with myself and Wayne. Wayne will get all your data. I really need to know a lot about your family, you know, how you're getting on with the kids, the in-laws, all that sort of stuff. I had a funny one recently that I went and saw this couple and they said, well, no, everything's okay. Everything's fantastic. And then they came down to Melbourne and they met their daughter's same-sex partner. And within about half an hour, they realised that their daughter was under control of the same-sex partner, came back and said, that's it, we need a family protection trust and a protector. So again, quite often it's not who you're with, who your child is, but it's actually who you're with, which is important. Okay, so if you've got any questions, just chuck them in the chat. Or importantly, you can just contact Wayne. Wayne will be following up on this, and love to get your details and have a chat with you. In a couple of weeks, I've got a few spots opening. I was going to go overseas, but I've got a few spots opening up. So normally my time is rare as hen's teeth, but come and have a look, and love to have a look at your circumstances.
Yeah, we certainly will be following up, Grant. But can you just touch base a little bit on recap on the SMSF will versus binding death benefit nomination and the difference and the benefits of having the SMSF will?
Yeah, absolutely. So when we go down, thank you very much for that. So I haven't touched much. And look, given the fact that I've written 5 books, honestly, I could sit and talk, and Wayne knows that. I can sit and talk forever on self-managed superannuation funds. When we have a look, and I won't go through it, negative gear anyway, you can come have a look. Key thing is when we have our self-managed super fund, and this also applies, believe it or not, a lot of the industry-based funds allow us to do this as well. So they're in front of many accountants in their estate planning strategy. So where you're over age 60 or 65, you can take a pension, which is your own private income stream. The benefit of there is all the assets that are underpinning that income stream are tax-free if you get income and you sell the property. So there's no capital gains tax. That's why it's so much more beneficial than negative gearing outside. Now you can have what we call a reversionary pension. So it goes, for example, to a spouse. But again, we don't want to necessarily go to the spouse because we don't want to load up too much in SMSF when we pass away, because when we pass away, we want our money to go out to our adult children. So our adult children can fit in there, or the spouse can. Ideally, if money is to be paid to the spouse, then what we want to do is, remember we went through this strategy, we want the spouse to get the money and waterfall it into the family protection trust, because we've got some protection going on there. Now, we don't have the ability of getting a 0% taxation, but what we do in that one is, because through a superannuation fund, we can't lend money to our family. So in our family protection trust, we can use those resources, and we do this for quite a lot of people, and they lend money to their children to renovate their house or upgrade their house or buy a deposit for a new home. So it's a nil interest rate. So it doesn't matter. We're not really worrying about the income coming in. We're actually using it to benefit our children. So that's useful. And because it's being lent out, it means that it's not matrimonial property. So again, that house that we've got or the office could be worth $1 million, but the $1 million actually owed there, which they're going to get in the long run because it's going to be split there. Now, in order to do these sort of things, or actually do a waterfall will, or if it goes to the children to make sure it's protected, it doesn't go into the estate, we do an SMSF will. So binding death benefit nomination is sort of vernacular that's taken on, that a lot of SMSF advisors take on, and I tell them, and Wayne's heard me say that, you should never use that, because there's been a whole range of cases where binding death benefit nominations, which are really for industry and retail super funds, that's why they were built there, have been litigated against. So we don't want to go down that track. So back in 2007, I created the concept of an SMSF will, which enables us to leave pensions or put into a death benefit trust down here, a super death benefits trust, or go over into our family protection trust. We can have a whole range of elements, so we can actually split up specific assets to different children. So we have a huge amount of flexibility, whereas a binding death benefit nomination just simply says we can give percentages to our children. So there's no flexibility. It's like, for example, okay, we're going to die, but all our kids are going to have a black Corolla, and that's all they've got. We want to have a lot of flexibility, and we also do that through the wills. We want to have as much flexibility as possible, because one of the things that I'm not sure if Wayne's told everyone is the government has started to look at intergenerational transfer taxes, which the head of Productivity Commission essentially said that that once it's over $500,000 a year estate, it'll be taxed at 20%. Now, Kerry's left some good words, so thank you very much, Kerry. So have to thank Grant. It was lovely meeting you, Kerry, for setting up a protective structure for my aunt and also for me. Again, I think that conflict, and that was really important to make sure there's no conflict, because the conflict in the family, and I can tell you, ends up being an absolute disaster. Is that the family ends up fighting and litigation, and it's, if you think of family law, if you've ever had anyone family law, that can be nasty. But many of you have probably had friends or family caught up in estate planning. I met someone the other day, and they'd been 10 years in courts, and they hadn't received anything from their parents' estate. Kerry, that's really important. The binding death benefit nomination or SMSF will to the legal person representative. That's dangerous, Kerry, because again, once it goes to the legal personal representative, it goes into your estate. So the first thing is, so for example, if I wanted to get funeral expenses, the first thing I would do, I can get that out of my self-managed super fund or super to pay my funeral expenses. All I have to do is show a death benefit certificate, and that's it. If it goes over to your estate, then it gets caught up in probate. If there's a contesting of the will or there's a family provision claim, you're not going to be able to touch that super for potentially years. So that's why Wayne's right, is that we want to make a SMSF will, try and pay out directly, and never ever leave it to the legal personal representative unless it's absolutely necessary. So for example, we quite often do that where we've got a member of a superannuation fund, they have no spouse, they have no children, they want to leave it to their nieces or nephews, we have to go over to the estate. But that's not bad, because if they've got no children, no spouse, then there's no family provision claim. So there is a window when it should be used. Otherwise, I would never ever use it. Back to you, Mr. Locke.
Okay, thanks, Grant. I don't know whether it was just me, but you went a bit quiet just then. I don't know whether it was secretive people's business that you were talking about, but anyway, that's all great. If anyone's got any questions, you've probably got a couple of minutes with Grant, then we're going to have to let him go. But first of all, thanks very much, Grant, for sparing an hour with us to go through all these strategies.
Yep.
I will be following everyone that's on here. There's a few people that didn't attend, so I'll follow them up as well. They'll get a copy of the webinar. The important thing is that none of us have perfect families. Like, I love my kids to death, but I know they're not perfect. So we need to instruct our successors, or we need to nominate who our successors are, and then instruct them what we want to happen. We can't just leave it to chance. And that's what this is all about. There's any number of different circumstances that can and will happen to people, and you need to protect your wealth against that, or for those changing circumstances. So once again, and as I said before, Grant's the pioneer in this area. If you can get hold of his family wealth protection, it's a fairly easy read. It's done talking a lot to his old man about what his father did and should have done, and then changed around. So it's not a boring old textbook that puts you to sleep. But believe me, I I go to bed and read a book and I'm asleep within 10 pages. But believe it or not, Grant, it didn't put me to bed, put me to sleep within 10 pages.
Well, fantastic. That's good.
So
right level.
I will be in contact with everyone. But please, if you want to reach out to me, please do so. If I haven't got around to you yet. So once again, thanks very much. Thanks, Divya, for organising this as well. And we'll be in touch.